Let's roll. Hi, everyone. Welcome to another ELTA Live event, the second one in this week. If you don't know who we are, ELTA is the European Legal Technology Association. You can look us up at elta.org, elta.org. And just a heads up, we are recording this webinar and we are streaming live as we speak. So you're on air, everyone. And it's my pleasure to introduce to you our speaker for today. It's Tea Kookmaa, and she will talk about the legal implications of using open source software, because we all use open source software. Probably a lot of us don't even know that they do, but there are implications. So you can't do with it whatever you want, but in more detail, Tea will explain it to you. So I will switch off my video and over to you, Tea.
Thank you so much for the opening words. I will then share my screen as well now. Just a moment. So I hope that everyone can see the slides nicely. Okay, great. So thank you all for joining. It is a pleasure for me to talk about open source software today in this webinar. Just a quick introduction about myself. I am an attorney at law. I practice law in law firm NJORD. I deal with IT law and data protection in my everyday practice. So our team regularly advises on different IT-related contracts, including license agreements. Also, our team advises different companies in various different fields regarding any IT law-related aspects or regulatory questions. And the other side of my what I specialize in, a big part of my everyday work, is data protection law. I have been dealing with data protection law for more than 5 years now. We regularly carry out data protection audits, legal legitimate interest assessments, and data protection impact assessments. And the two fields, IT law and data protection, are also very much related to each other in many cases. So this has given me like a comprehensive view on the topic. And today we will be speaking about open source software. Our webinar will last approximately an hour. If you have any questions during the webinar, then you are definitely more than welcome to ask and comment. You can use our chat, and of course you can also use the microphone. But we will also have some time for questions at the end of the webinar as well. So what we want to learn about today, first we will start by explaining what exactly is open source software. This is important to explain and clarify because the term open source software has kind of attributed many different definitions, because open source software is very widely used. It has many advantages. We will also speak about them during the webinar, but it is important to understand what does open source software mean in the legal context. What exactly does it mean regarding the rights and obligations for those who want to provide software as open source, as well as for those who want to use an open source software? We will then take a look at the different license types. which open source software can have. And we will briefly discuss how they differ. And then moving forward, we will take a look at two different perspectives. First of all, the perspective of a licensor, the one who is providing a type of software, wants to provide it as open source, but needs to decide which type of license terms to draft. And then we will also take a look at the other important perspective, which is when you are either a user, if you are a software developer yourself, a software developing company, for example, and you want to use open source software to develop your own service or product. And we will take a look at the different license types again to understand how they differ and which one should the person who wants to use the open source software, how should you navigate between the license terms and which type of license and the software type accordingly should you choose. And we will also briefly discuss overall the terms and conditions for open source licenses and take a look at some very standard topics which are usually covered when speaking about open source license terms and what should you look out for. And we will discuss what are the risks for using open source software, the legal risks, and how to mitigate the risks. And hopefully what you will learn during this webinar will give you a better picture, at least like a brief understanding of what are the most important aspects to read about carefully in the open source license terms and what to look out for. But first, let's start by talking about open source. What does the term mean exactly, and what is open source software? So a lot of software developers, a lot of companies, service providers, startups are in many cases referring to the fact that I plan to use open source software, or they express the idea during their team meetings to their supervisor or their company. Over time, I believe that this term has attributed kind of like a wrong meaning, which is often misleading to either the company or the person who wants to use open source software. Open source is very often equated with the meaning of like free or software which is in the public domain, and that actually is incorrect. If we take a look at what open source software license actually means in the legal context, then an open source license means that the customer who intends to use the software, who is going through the software license agreement and has to accept the license agreement to obtain the software, that this customer will be given access to the software's source code. Also, an open source license permits modification of the software, that is correct, and redistribution of both the original and the new modified version. So as we can understand, an open source license means that the customer gets to access the source code, can make modifications to the source code, and can itself redistribute both the like the derivative software, the new software which is obtained by making modifications to the source code, as well as the original software. So we can already understand what is kind of behind the popularity and the wide use of open source software. because we can already understand that it can greatly contribute to the development of very good code, very functional and reliable software. It greatly contributes to the evolution of good quality software, because developers can make modifications, fix bugs, and add new functionality, and the the better software can circulate among the crowd, so to say, and new developers can make additional modifications to it. So in terms of open source software, there are two important parties which we will be referring to throughout this webinar. I will be speaking about the licensor. The licensor is the one who has the software which the licensor wants to give out to other parties under a license agreement. So this will be called the licensor. And the other party who would be receiving the software, either to use it himself or herself, or for the benefit of some specific project, or for developing some new software on top of it, this party will be called the recipient. I don't want to use the term vendor, because oftentimes when we are speaking about open source software, actually both parties, the licensor and the recipient, these may qualify as software developing companies as well, because open source software is very often why people want to use it, or why companies want to use it, to develop their own products or services, to incorporate it into their own development projects. So licensor and recipient are better terms to understand and explain the rights and obligations for the parties. So let's proceed by kind of debunking some of the myths about open source software. First of all, open source software is not necessarily free. As we saw from the previous slide, an open source license grants the customer access to the software source code, permits modification of the software, and redistribution of both the original and the new modified version. However, open source is often confused with being free, but open source software may not necessarily be free of charge. Even if the software developing company wants to use an open source license in the license agreement, then as the licensor, this entity can still charge for the software. And this would still be considered the provision of an open source software, as long as any royalty or additional license charges are not applied. So the first aspect to remember and to take note of is that an open source license may not be free of charge. And in practice, though, as I was explaining previously, open source software is widely used. The whole essence of open source software is that modifications are allowed and the original source code is accessible to the recipients. And therefore, in practice, yes, open source software, it can be free or tends to be rather inexpensive. And the reason is the situation which is being created on the market. The charges for an open source license tend not to be very high because of the just the like logical market reasons that if the licensor would apply very expensive charges, then the recipient would turn to another provider of the software, and this tends to make the open source charges rather inexpensive. And this again has created a situation which is very good for the benefit of the developers community, that open source software is widely used and circulates around the community of developers, allowing them to fix bugs, add new functionality, and then release the modified and the better versions of the software again. And also, in many cases, many licensors who license software as open source, they even do not care that much about making money directly from licensing the code itself. Instead, usually in many cases, when we look at the business models that these entities have, they generate their revenue from related professional services, for example, tech support, consulting, or some type of related technology. Also, we can understand this very well when we look at what is happening on the IT market in general, and in general in the world of digitalization, actually. In the last couple of years, a great rise has happened in the field of no-code and low-code platforms, for example, and they apply the same logic. They allow their platforms, which are either no-code or low-code, to be used widely for a relatively inexpensive charge. And the business model behind it is that they generate their revenue because they actually want users to build new services and products on the templates which they provide on their platforms. So they don't make revenue directly from providing the use of the platform. So the business model is different. And also, there are individuals who write software just for the glory or the fun of it. So this is another reason why in the developers community, open source software tends to be rather inexpensive. Also, sometimes open source is confused with the term code, which is in the public domain. Again, we cannot equate the two terms. Software which is in the public domain means that the software is really entirely free of copyright and other intellectual property restrictions. Software in the public domain means that no one needs a license to copy it, and we are all free to make modifications, distribute new versions, and so on. However, in contrast, open source software, it is licensed. So a license agreement is a contract between two parties. A license agreement imposes specific obligations and rights to both parties. Open source software is licensed by its definition, and open source software is governed by copyrights law. Therefore, for example, if you are in the position of a licensor, if you are developing code and you want to provide it on the market as open source in your mind, then it is strongly recommended to be very careful with terminology. So you should not use the term public domain when what you actually mean is open source. This is important because if you confuse the terms and use them loosely, your customers or cooperation partners can also be confused, and they may expect that the code is completely free of any rights and obligations, whereas you as the licensor intend to provide it as open source, meaning that we will in a few minutes be talking about different types of licenses, you want to provide some terms for your code. So it is necessary to not confuse the two terms. Public domain is something completely different from open source. Open source software is always licensed by definition. And it means that there is a licensor who is providing the software, is also providing a license agreement draft to be reviewed and signed by the other party who will be using the open source software. So as has been said, open source software is governed by copyrights law. Perhaps the wording of the term open source creates confusion and like a wrong impression that you can do whatever you want to with the software, but that is actually wrong. An open source license actually grants freedoms that are just not so common in other commercial licenses. They are a bit more lenient, but they are not non-existent. And also open source licenses can have some unique restrictions as well in many cases. Therefore, the first takeaway is that if you want to use open source software, you need to familiarize yourself with the license agreement and the exact terms of the license agreement, because otherwise you may be in infringement in front of the party who is the licensor and who is providing the open source software. Again, why is open source software so popular? It actually has its both pros and also some cons. So some advantages and also a few disadvantages, which are actually also necessary to consider, depending also on which side you are. Are you the licensor who wants to give out specific software to be to have it used by other parties on the market, or if you as a company or maybe as an individual want to incorporate open source software into another software which you are developing or are having developed by your cooperation partners. So the main advantage is the evolution of the code. It means that the code can circulate widely. It reaches different developers who can fix bugs, add new modules, and otherwise revise the software. The software is improving continuously, and those who are using it can sort of reap the benefits of the improved software because it is open source. So basically what it means is that we could phrase it as software quality improvements through natural selection. Because there is, for example, one specific type of code, different developers basically all over the world can access it, not entirely freely necessarily, as we have learned already during this webinar, but can access it, can make modifications to it because this is allowed. This is the definition of open source. And better software is created. Also, because open source means that access to the source code is given and modifications can be made, there can be a specific downside or disadvantage as well. Because open source means that access will be given to the source code, each recipient or each user of the software can redistribute it and start competing with the original creator of the software. This can mean that the license revenues of the original licensor may decrease. In addition, this is also something important, and it can also relate to protection of confidential information and protection of business secrets. A source code for a software can often include sensitive techniques, very specific know-how, and open source means that these techniques and the know-how will be shared with competitors. So this can create a situation where competitors can reap the benefits from this, and for many, this may also mean that perhaps the company does not want to issue software under an open source license. So this can definitely be an aspect which should make you think twice if you know that the original source code for your software contains very sensitive business secret related techniques, and you don't want a situation where this will be shared with your competitors. We can see that more and more open source software is being released on the market. It has been so for many years now. As I mentioned at the beginning of the webinar, a recent new development in the IT world is also the rise of no-code and low-code platforms as well. Many of the no-code, low-code solutions are also open source, not all of them though. Not all no-code, low-code solutions are open source, but many of them are. And for example, here is just to illustrate the point. Here is a news from TechCrunch, which spoke about how the widely used no-code solution Airtable received a competitor on the market called Baserow. As the title of the news goes, Baserow challenges Airtable with an open source no-code database platform. And also the news contained some explanations about how it is a quite important competitor for Airtable, and we can see how the open source part of it is actually creating the advantage and the competitiveness. As it says, some sectors require full control of their data and technology stack for security or compliance purposes. This is where open source really comes into its own, given that businesses can host the product themselves and circumvent vendor lock-in. And also, it has been highlighted that one of the benefits of open source can be that the solutions which are open source can be especially customizable, and this can be a great benefit for companies who want to implement a new IT solution, but the so-called off-the-shelf software as a service solutions do not provide the right functions and are not as customizable as the company wishes. So these are some of the reasons why open source software is so popular and why it really has its advantages. So as was mentioned, open source is licensed by its definition. Open source does not mean that the user has no rights or obligations at all. And also, as we learned, open source software does not necessarily need to be free. Now let's take a look at some of the main types of licenses which are used in open source and how do they differ. And we will be speaking about the two main umbrellas of license types. When developers develop open source software, then what has become very popular on in the field is that the licensors, they rarely draft their own open source license. Instead, there are quite a few so-called standard license forms, which are widely used in the open source community. And there are two main types of licenses which we can distinguish in the open source community. And these are called, first of all, the copyleft licenses, and then the permissive license types. Both of them are open source, but they are fundamentally different from each other. And let's take a look at the differences. So what does copyleft license type actually mean? This is a license type in which the code, which is derived from the original open source code, inherits the original license terms. So basically, copyleft license terms require that any recipient of the software must also use the open source model if it decides to redistribute the software itself. Therefore, copyleft requires that all future or so-called downstream recipients use the same open source model if they decide to redistribute the software themselves. And you can already probably understand how this can be both an advantage and also kind of a disadvantage. Many companies find themselves in struggles because they have discovered that there is some type of open source software available on the market, easily accessible, seems very suitable to be included in the project where some kind of a new service or product will be developed. However, they do not understand the core or the essence of the copyleft license. And therefore, these entities can find themselves in a kind of nightmare because let's imagine, for example, that there is a software engineer who is working for another developer, and this software engineer decides to include a small amount of copyleft licensed software in a massive system without letting the project manager or other people in the project actually know about this. So what this means now is that the whole system now is kind of infected. It is all now open source software. And this is also the reason why some people in the community of open source or some developers as well often refer to this type of license as a so-called viral license, because if you take a small amount of software which has been licensed under the copyleft license type and you incorporate it into a software which you are developing, then this means that the whole software now is considered as open source. And if you want to redistribute this now in turn, then you need to redistribute it under the same open source license terms as well for your own clients, for your cooperation partners. One of the most well-known copyleft licenses is the GPL. That is probably, it has a few different versions. It is probably well known to many of the people in the audience as well. So this was the copyleft license, and as I mentioned, one of the most well-known copyleft licenses is the GPL. However, there are a few others. We will not go deep into all the different license agreements terms which we can find in the different license agreements and the documents worldwide, but just to it is important to remember and understand what is the essence of the copyleft license type. That the essence is that if you redistribute the software on your own in the future, then you must redistribute it under the same license agreement type. So this is very important to consider. And if you decide to incorporate a specific piece of code into your own software, and that piece of code has been licensed under the copyleft license terms, then very carefully consider the fact that the whole software will be under the copyleft license. So if you do not want this, you probably should take a different piece of code to incorporate into your own software. The second big, or the umbrella of license types is the permissive type of open source license. This is very common. Actually, most open source licenses, they lack the copyleft provisions. What they do is that they allow the recipient, the user of the software, to include the open source software in a larger program, and then they allow to distribute that program under just any license terms which the new licensor wants, and with or without the open source model. So it can be decided that the new software which will be distributed under the open source model, or that it will not be distributed under the open source model. It is possible to redistribute the software under a more strict license agreement. And here, under this category, the BSD types of licenses are perhaps the most well-known. For example, the MIT license. So it is important to understand the fundamental difference between the permissive and the copyleft license types. If you look into an open source software which has a permissive license type, then this means that the so-called derivative software can also be released under a different license type. However, if the software has been licensed to you under a copyleft license type, then if you decide to develop the original source code further, you end up creating a new software on its own, and you want to release this into the market on your own, then beware that you cannot release it onto the market under another license. You need to kind of keep going with the same type of license and the same terms. And of course, in all cases, this is also said in the license agreement that any new distributor of the software must include the same license agreement terms in their own license agreement. Copyleft licenses, they generally have more restrictions in their license agreement clauses, and possibly less liability than permissive licenses. So this is also something to consider. And whether to use open source or not to use open source, it depends a lot on what exactly is your aim. What exactly is the project about? What is the service about? How risk tolerant is your company where you are operating? For example, if you are working as a software developer, you want to incorporate open source code into your project. Also, it depends on what is your overall company policy. It may be also restricted on a higher level in your company that open source code is not used or may be used. So it depends on a lot of factors. It is best to look at the different options depending on whether you are a software provider or the licensor in other terms, or if you are a potential recipient of the software. So let's imagine that you are a provider of the software. You have developed some type of software. You are in the role of the person who can provide the software to recipients. You are in the role of the licensor. You can draft license agreements and give access to the software. Then in that case, you probably want to draft the license agreement terms as copyleft if you want to make sure that all the other users of the software would be redistributing the software as an open source model on their own. So if your overall aim is that the software which you have created, which your team has developed, would be circulating on the market as open source, would definitely benefit from the natural selection or the evolution of the code, as we discussed at the very beginning of the seminar, then probably you should choose the copyleft license type. And the specific clauses, the specific warranties which you want to include in the license terms, these depend further on the aspects of your project, on the situation you are in, and your business aims as well. And as was mentioned, there are many different types of licenses available on the market. Now, if you are a potential recipient of the software, the entity or the person who would be using the software, perhaps also incorporating the software into your own software development activities, then what kind of considerations should you take into account? If you have found some type of software, you can see that it's open source, and you read into the license terms and you see that they are copyleft. Then if you are in the role of a recipient, this is probably not a problem for you. The users of the software, they probably benefit from the software being copyleft because it means that the software will be open source, throughout the future. The software will gain the benefits of the continuous development, the fixing of bugs, the improvement by different developments on the market. And as a user, you will also get to make use of the benefits because it is under a copyleft license and it is open source. If you are in the role of a recipient, but let's imagine that you are a software developer yourself, and let's imagine that you would like to incorporate the open source code into your own software development activities. Maybe you have big plans for your own business, and you already know from the very beginning that you don't want to provide your own derivative software under a copyleft license. Maybe you want to have a stricter license for your own customers. Then in that case, as I also mentioned earlier, you need to make sure that you do not incorporate copyleft licensed software into your own software. This is definitely what you should do. And yes, this needs investigation, and it can be difficult, especially if we are talking about massive projects with a massive amount of software development and perhaps many cooperation partners in the project, also maybe in different countries and so on. But it all comes down to the fact that you need to investigate and look into the software and make sure that you will not incorporate copyleft software into your own software. That is just the case because as we looked at one of the examples earlier, the thing with copyleft licensed software is that they sort of can infect other software, and then it all becomes open source. That is the case. About permissive licenses, if you are in the role of a licensor, when should you choose a permissive type of license if you want to release the derivative software on the market? You should choose, or you could choose, a permissive type of license if you do not care so much about whether the recipients, for example, your customers themselves, will be using the open source model or not, if they decide to redistribute your software. So if you do not care, you may just use a permissive type of license. And if you are in the role of a recipient of the software, then this actually is pretty easy. If you want to incorporate a piece of code into your own software development project, then a permissive type of license is it's not a problem at all, actually, because, as was explained easier, a software which has been released under a permissive license type, it can be redistributed under another license type. So if you can include a piece of code which has been released under a permissive license type, and the final end product which you or your company will be developing, this in turn can be released under a more stricter license type. That is perfectly okay. So if you're in the role of a recipient, you do not need to think very much about this issue. And the final thing which is necessary to emphasize is that always make sure to read your license terms, because today in this webinar we speak about the main types of licenses, and we speak about what does open source actually mean. And as we can understand, open source is not necessarily free. Open source has its own rights and obligations for both the licensors and the recipients, but the details about the terms and the important details which will determine how exactly can you make use of the specific software in your everyday practice, in your everyday work, these depend on the license terms. So definitely make sure to read the license terms before you begin to use a specific type of software, and also make sure to read the license terms if you are in the role of a licensor and you decide to make use of a, for example, the MIT license or some other types of licenses already drafted and available on the market. Also, as a practicing lawyer, perhaps a few tips regarding open source and the drafting of license agreements, which I have some tips which I would like to share, perhaps about what I have seen in my everyday practice as a lawyer. I have seen many license agreements for software where the licensor states that our software does not contain any open source. However, as we have seen during this webinar, you should be quite careful with a statement like this. If you, as the software provider, if you are not entirely sure that your software, which you have asked to be developed by different developers, maybe around the world, by your cooperation partners, if you are not 100% sure that it does not contain open source, then don't say this in the agreement. If you do so, then if it actually contains open source, this can bring about disputes, and you can end up in a dispute with the other party of the agreement, and also compensations for damages may be may be demanded from you. So if you're not sure that your software does not contain open source, then it is best to leave it unregulated even. Do not state confidently that there is no open source. If you state this, you better be sure that there is none. And of course, being sure that there is none, this again comes down to the agreements which you have with your own vendors and your own software developers, right? Because you should have told them before that when they are developing software for you, they should not be using open source. If this is what you want as an entity, then you must state this in your agreements with your cooperation partners. Is it important for you that the software would not contain open source? This depends on what are your business aims, what kind of a company you are, what is your policy. But if it is important, then you must investigate the software. If it is important for you that you would not incorporate into your own activities an open source code, then you must investigate this, because if the code which you want to incorporate into your own development, if it is open source, then this basically is like a defective product or service for you in that case. And don't forget about looking into the license fees when you are reviewing license terms. Because as we said previously, open source software does not necessarily need to be free. And in many cases, there are license fees to be paid. You need to make note of these. You need to look into the payment terms. Also, there may be contractual penalties as well in the license agreements, because contractual penalty is a very easy legal remedy which the licensor can apply in the contract, and it is very widely used as well. And it is important to read the license agreements. It is widely common in the field that the license agreements, because they tend to be lengthy and burdensome, that they are not investigated or studied enough. But this just creates a risk for you. And it can also be acceptable that you as a company decide not to look that deep into the license terms. But in that case, you must accept that it creates a risk. You do not know the license terms. You do not know how you can or cannot redistribute the code. How exactly can you modify the code? Do you have to make any payments to the licensor or not? You do not know the terms, and this creates a risk. In some cases, the risks can be acceptable, but you must understand that they are there. And of course, it can be a good option to incorporate a legal service provider to help you understand what the licensing agreements are about. Many law firms help companies to carry out a sort of, we usually call it like a red flag review of license agreements, which mean that we review the license agreements for the open source or any other type of software which you intend to use, and we bring out the main risks for you as the user. Which means that with the help of a professional legal service provider, you can make an educated and informed decision about whether to use one specific type of software or not, and whether the license agreement clauses are actually acceptable for you. So if you do not have any resources of your own to look deep into the license terms and understand the risks, then it is definitely a good idea to incorporate the help of a professional legal service provider to give you at least a red flag review of the license agreement. In addition to fees, in addition to the fact that an open source license can be copyleft or can be a permissive type, then there are many other important terms in open source licenses. the most important are warranty disclaimers, which are usually included in open source terms. Open source software is usually provided in a so-called as it is condition. So it means without any express or implied warranties. Usually the licensor wants the downstream recipients, those who get the software directly or indirectly from the original recipient, to not expect any warranties either. So this is why a specific warranty disclaimer is usually included. I already mentioned that contractual penalties are also common. A license agreement is a very specific type of contract, and any obligations included in a contract can be tied to a contractual penalty, and a contractual penalty is very easy to be enforced by the licensor. So always look out for contractual penalties. Also, I'm very often amazed as a legal professional myself how little companies and people know about contractual penalties overall. Contractual penalties, the sum of contractual penalty does not come from the law. So when you scroll over a license agreement and you submit accept very leniently, and you do not read the terms of the license agreement thoroughly, this can be very risky for you, because there may be quite high sums of contractual penalties included in the license agreement, because in most jurisdictions all over the world, the law does not prescribe any specific sum of contractual penalty which may be included in the agreement. A sum of contractual penalty, whether it is, for example, 500 euros, 1,000 euro, 100,000 euros, or any other sum, this is just to be agreed on by the parties who signed the license agreement. So this is why it is important for you to look out for contractual penalty clauses. Also, what are very common are limitations of liability for the licensor, and also the choice of law and jurisdiction clauses, which as lawyers, we also strongly advise companies to look out for and review. If it should happen that you or the other party of the license agreement breaches an obligation and a dispute arises, and if it should go to court, then it may happen that you surprisingly find that you have to sue the other party in, I don't know, Argentina, for example, but you would like to sue the other party in the country where you reside, for example, in Estonia, where the rules which courts abide by are much more familiar to you. So therefore, it is strongly advised to review what are the choice of law and the jurisdiction clauses as well, especially if you imagine that the cooperation partner would be for a long term for you, because legal disputes can arise in cooperation with our cooperation partners. And it is important for us to know that if we would take the legal dispute into court, in which country would that be, and would we be okay with that? So this is also important to look out for. And that is actually all from my side, because we are also running out of time. To conclude about open source code and the use of open source software, it is important to understand that open source software is not necessarily free of rights and obligations. Open source software always comes with a license agreement. You need to read and review it. there are some very important aspects to always keep in mind. First of all, what type of license it is. Is it a copyleft type of license, or is it a permissive type? This already gives you quite a bit of a clue about how exactly can you make use of the open source software yourself. Also, pay attention to liability clauses, warranties, contractual penalties, which are very often drafted into license agreements, because they are the easiest legal remedies, like preemptive legal remedies, which licensors usually want to apply in contracts. And also, it is important to pay attention to the choice of law and jurisdiction clauses. And as a final conclusion, open source software is definitely not anything negative. It has great benefits, as we learned today. It allows us to benefit from the continuous evolvement, the evolution, and the improvement of the software. It is just important to understand that it always has some obligations and rights attached to it, which impact both parties, the provider of the software and the one who makes use of the software. So that is all from my side. Thank you for listening. And if we have any questions, then we can answer them as well, if we have any questions from the audience.
There haven't been any questions so far, apart from the sharing the presentation in the chat. But if some of you have a question, just unmute yourself and ask. No questions. Then thank you very much. Oh, there's one. No questions. Thanks, everyone. Okay, good. Tea, thank you so much. Was very informative. A lot of information to process. And I guess if somebody has a question to you, you have seen, you see the email, reach out to Tea, ask her away. She is an expert in that matter. So see you next time at the next ELTA live event, and have a good day.